First introductions. This is me. I'm Emilie Goldman. I'm a financial planner in my professional life, and I'm passionate about creating financial freedom for busy families. And to me, what that means is that we're free from anxiety and worry that build up when we don't plan, or we don't even really know what's the next step to take. In my personal life, I'm a mom, and I know how challenging it can be to manage a busy family schedule, and on top of that, find some time and energy to focus on the longer term, big picture financial decisions. So I commend you for taking the time today.
Good afternoon, everyone, and thank you for joining Emilie and myself for the webinar. My name is Brigitte Binkert, and I'm a trust and estate lawyer in Mountain View. Like Emilie, I have my own practice, and I help clients develop and set up their estate plans. I also help with trust administrations and probate if needed. I'm also the mom of 2 children. They're 9 and 12 years old. And like every other parent, I do worry about what would happen to my children if something happened to myself and my husband. So during this seminar, I would like to introduce you to the basic estate planning documents everyone should have in place for a situation where one spouse or both spouses pass away, possibly leaving minor children behind. So I hope that this webinar will provide you with some useful information and provide some answers about what steps you can take to protect your children and your loved ones. Thank you. And with that, I will hand over to Emilie for the first part of the presentation.
Great, thanks, Brigitte. So I'll get our presentation started by creating some context for all of those financial planning things you know you're supposed to do. I find many parents I talk to know the components of a financial plan, but they're just not sure where to start and what the priorities should be. So I'm going to start with that. And I will cover 3 categories here. And again, these are really sort of the basics, foundational tools that every family really needs. I'm going to cover protection, know your numbers, and then Brigitte will cover your estate plan. And these are the tools, again, you use to build your financial foundation. Advanced tools would be, so just to put this in context again, we're not going to cover these today, but you can definitely check out our future webinars. We have regular webinars and my blog, other resources on my website for these topics on retirement saving, college saving, and in investing. So some more resources there. And these are certainly important topics. But Brigitte and I are just going to cover the foundational components today. Insurance, cash flow planning, and estate planning. These are all things that parents often avoid. In fact, when I see clients, many of them have made progress on these more advanced topics without having covered the more basic topics. So I think it's really important just to reiterate how important these foundational aspects are. These really lay the foundation of your family's financial plan. And without these tools, any saving and investing you do can be at risk. So starting out with protection, insurance. So we'll look at life, disability, liability, and a contingency fund here. So life, there's kind of what to say about life insurance. It's a big topic. It can be confusing for parents, and that can make it easy for us just to get stopped by just the basic idea of facing our own death. And once we overcome that block, we need to figure out what type and how much insurance to buy, and that of course can be overwhelming. My financial practice is fee only, so I don't actually sell insurance products, but I do help my clients answer these questions. And one that comes up consistently is how to decide between term and permanent life, because often what happens is you need life insurance, you go talk to a life insurance professional. Often those people are incented to sell you whole life insurance, so then the whole thing gets really complicated and you have to try to figure out What's the difference, term and whole life, and what do you really need? So a good analogy is to sort of make the distinction between the two. Term is more like renting, and permanent is like buying. Term covers a specific period of time, say 10, 20, or even 30 years. You pay fixed premiums over that term, and at the end of the term, either the coverage ends or you may have the option to convert the term policy to a permanent policy. So that, of course, would make the cost go up. And I'll talk a little bit more about that. But term will have significantly lower premiums than a permanent policy of the same coverage amount. And so term makes sense for most families because they have a large exposure for a fixed period of time, typically while the kids are young. In other words, the impact of loss of income or at-home support of one or both parents would have much more financial impact than when the kids are grown and self-supporting. Insuring this risk with term life will be affordable for most families. And also many employers offer term life as a benefit, so you may automatically have some coverage through your employer. And that's an easy way to get started. However, healthy parents may find better and cheaper private coverage, and when you really go through the numbers, you are likely to find that you need more coverage than what your employer offers as a benefit. So that gets us into how much you need to buy. I think it's pretty handy, if you're not already working with a financial planner, use an online life insurance calculator. If you just Google on life insurance calculator, there's quite a few out there, just to help you think through what are the pieces, what if something happened to you and you didn't earn, or you're a stay-at-home spouse and you wouldn't be there to care for your kids, what would your family need? So the online calculator just helps you walk through those pieces. How many years of income would need to be replaced? If you have debts, would you want the mortgage to be paid off? Other things like college costs, other goals that you have. So you add all that up and come up with a number for the coverage that you need. On the other hand, permanent is, as the name implies, permanent. It's designed to remain in place until the eventual death of the policy owner. And it makes sense that this type of coverage requires much higher premiums because, one, the time period covered is much longer and death is certain. So payout on the policy is certain versus term where only maybe 1 or 2% of policies ever pay out because coverage lapses before the insured dies. That's unusual that a term policy would pay out, and that's why it's so much cheaper. But if you as a parent are insuring a risk with a limited term, then term insurance works best, period. And it's cheaper. Permanent insurance can make sense. There is a place for it. Specific cases like funding a special needs trust on the death of the second parent in order to support a special needs child, or if you're needing to pay estate taxes, which for most people, this, at least at the moment, is not an issue because Brigitte will touch on this, but the exemption for estate taxes is very high right now. So term, typically the way to go, a quick online calculation, you can figure out a coverage number and see if your current employer coverage is enough for you. Super important. Disability. This insurance replaces a portion of your income if you become disabled and cannot work. And since parents are more likely to face disability than death while raising their kids, and the impact can be financially devastating, this is a critical coverage need for all parents. Most employers offer this as a benefit, and they may have an option even to increase the coverage amount from a basic level. So this can be an easy way to get coverage, though it may not be the cheapest or the best. And one thing I've seen lately, I would say be sure to ask how long the coverage lasts. So say you're 45 and you become disabled, is that coverage in place until some typical retirement date like 65, 67? Because I have definitely seen employer policies now where the coverage is only for a couple of years, which in the case of permanent disability would not be nearly enough. To cover the risk of permanent disability, you need the coverage that continues until your expected retirement age, or when you assume you would stop earning in any case. Often the employer policies, if you have it, are portable. So when you leave an employer, you may be able to take it with you. If not, that's also an issue where you may want to have, or a scenario where you may want to have your own coverage. Where private coverage you can get, it can be tailored to your needs and even be used to supplement a policy you have through your work. That's something to really learn about what you have in place and what you might need there. Last piece on insurance here, liability insurance. So this is your homeowners, your auto, your umbrella. And what I see typically, umbrella is most often missing from the insurance portfolios of the clients who come to work with me. Umbrella policy is designed to increase the liability protection over and above the standard one that's always in your home and auto insurance policies. The personal umbrella extends your liability protection beyond the primary policy limits and is usually sold in $1 million increments. An umbrella may be obtained once your home and auto insurance policies meet a minimum attachment point. So typically this is $250,000 or $500,000. So you just need to check your broker can help you with this, but once you reach that limit, the personal umbrella policy then kicks in and covers 4 elements: personal injury, bodily injury, property damage, and defense coverage. Umbrella coverage can protect you against personal liabilities that could attack a substantial portion of your assets or even future earnings. For a few $100s a year, it's really very cheap. You may add an umbrella policy or increase your policy limits to balance with your growing assets and other risk factors. And you want to talk to your personal insurance agent about this really important coverage. Things that can happen there, even simple things that we do every day, carpool, driving other people's children around in our car if something happens, even through no fault of our own, often a suit will be brought. And even if there's no judgment won against you, that just the cost of covering such an event, covering all the lawyer fees, would be substantial. So that's why this umbrella policy is super important. And again, really inexpensive because it rarely pays out. Like, these things rarely happen, but the thing is, if they do, they are substantial, in the millions, very commonly. All right, one more piece on protection, sort of moving beyond the insurance piece. And be sure to, just a reminder to type your questions in the chat box. If you don't see the box, you might need to click on the chat word there with a little arrow next to it to expand your chat box where you can type in a message if you have a question. Okay, so job loss is the likely scenario for most of us, especially here in startup and technology land. So your contingency fund should hold enough cash to cover 3 to 6 months of your household expenses. And that might depend too, if you think it might take you longer to find the type of job that you currently have. You might want to hold more cash. And by cash, I do mean cash, bank accounts, CDs, possibly a very short-term bond fund, but something that could be quickly converted to cash. If your career is more volatile or specialized and requires frequent job changes or longer job searches, like I was mentioning, you might be at the higher end of the range or even hold a little more. Where a 2-income family with some job security might be at the lower end. Okay, so moving on from protection, we're going to start with know your numbers. And this is really a super basic tool, can be done for free. Knowing what you spend is the most important input into a personal financial plan, right? This would determine all the other numbers, like how much disability insurance you need, how much life, how much liability, how much contingency fund, all those things, let alone like how long till you can retire, right? All those things are driven by how much you need to spend on a daily, weekly, monthly basis. So unless you know how much you need to live on, you won't be able to calculate all these things. You won't really know when you have enough. And when you can further break down your spending patterns into some categories like basic and fixed expenses, discretionary spending, as well as future spending goals, you'll have the foundation you need for making wise financial decisions. Your basic toolkit should also include a way to track your debts and assets. You probably know this, but all of your assets less your debts, that's your net worth. And ultimately, this is a metric for tracking your financial progress. Your net worth will determine your insurance and estate planning needs and point you toward your financial priorities. For example, should you pay down debt or save more for retirement or college? And even thinking about making an investment in your career, for example, should you do that, where that might reduce your immediate net worth, but increase future earnings potential. So all of those things kind of flow into this idea of growing your net worth. Knowing your numbers. So from a cash flow perspective here, there's some terrific free resources available online for tracking cash flow. And typically they track net worth as well in the same tool. I've used a few of them. I personally started with Quicken, and then I tried mint.com, and I found both of them useful, but mainly for looking back at past spending. And that's really important for creating spending baseline or for preparing taxes. But I think both programs fall short, or they did fall short supporting me in real-time decision making. And for that, I'm now using First Step Cash Management. I teach all of my clients how to use that. YNAB, that one in the middle there, stands for You Need a Budget. Although I hate the term budget, but maybe that's why they went down just to the acronym there. That's a terrific tool that also offers classes and support. That's really nice way to sort of be held accountable and have questions answered about how their tool is working for you. That's a one I would also recommend. Personal Capital is another one. There's quite a few of those, along with other robo-advisors, where at least for free you can connect all your accounts, see your net worth, see your total expenses, similar to Mint, but then they may offer some other investment options as well. I offer a regular webinar on First Step, and I'll have new dates going up shortly. So if you join my email list, you'll get information on those in the future if you're interested to find out more about that. But the critical thing is just to have a way to track this. And I think I said this, but really you're not alone if you don't really have a good handle on what you're spending. I would say most people who come to work with me don't. This is one of the areas that we really need to focus on because it drives everything else in the planning process. So we covered protection and know your numbers. Before Brigitte enlightens us about estate planning, I want to remind you to stay tuned till the end of our presentation, not only for the awesome information from Brigitte, but we'll have a special offer. Both of us will have a special offer for everyone on the call today. Okay, Brigitte, take it away.
Okay, thank you, Emilie. First, I would like to show you a short roadmap of what I'm going to cover in this second part of the presentation. So on this slide, you can see, first I will be talking about the components of a basic estate plan, which will include a will, a trust, an advanced healthcare directive, and a power of attorney. And I will also talk about guardianship for children. And in the next section, then I will talk about how the estate plan works together, in which situations you need these documents, and how they are connected. And in the third part, I will talk about some considerations for international estate planning. So what are some of the things international families have to think about? And this applies whether you are a US citizen with assets abroad or a non-citizen living in the US, or maybe you even have some family members living abroad that are affected by your estate planning. So let's get started right away with the first document. On the next slide, this will talk about a will. A will is a document that states your final wishes, and you use it to decide who should receive your assets in case of your death. And in this document, you also name an executor, and that's the person who manages the estate, deals with the probate court, collects your assets, pays the debts, and then distributes the property according to the terms of the will. The executor is sometimes also called the personal representative. And if you don't have a will, then the court will appoint an administrator, just so you know the terminology. So with the will, you decide who receives your assets, how the debts and taxes will be paid, and the will also serves as a backup to a living trust. And in that case, it's called a pour-over will. And maybe you've heard that expression in the past. And I will talk about the trust on the next slide. In the will, you also name guardians for minor children. And I will also later on talk a little bit about that. Like I mentioned, many estate plans also include a trust. And I would like to talk a little bit about what a trust is, because sometimes my clients find it difficult to understand because it's not something you can touch. But a trust is basically an arrangement, or similar maybe to a contract, under which one person, who is called the trustee, holds legal title to the property for another person, who is called the beneficiary. And so you can be the trustee of your own trust during your life, and you keep full control over all the property held in your trust. So when you set up a trust as part of your estate planning, an attorney drafts the trust document and spells out who the trustee is. It would be you during your life, who the successor trustee is in case of incapacity or death, and who should receive the assets in case of death. Once the trust is set up and signed and effective, then you need to transfer your assets into the trust. And that basically means you go to your bank and you change the title of your bank account from your name to you as trustee of your trust. So typically you get a form from the bank and you tell them, I set up a trust and I need to transfer my accounts. So there's a little bit of paperwork involved, but the financial institutions know how to do this and will help you. You will also transfer a house, if you have one, into the trust, and that's done by recording the deed in your name as trustee of your trust. All of this does not change how you control your accounts or how you pay taxes, and you can at any time change the trust or revoke it, and transfer assets in or out of the trust. Some assets, such as retirement accounts or life insurance, are not transferred to the trust. And that's because they have beneficiary designations. And the assets will go directly to the beneficiaries upon the death of the account or policyholder. So that's just something to keep in mind. And that's actually an easy estate planning tool that you can use right away. Whenever you set up a retirement account or you buy life insurance, make sure you designate the beneficiaries right away. You don't need an estate planning attorney to do that. The big advantage of setting up a living trust is that the property that you leave through the trust doesn't have to go through the probate procedure. As many of you probably know, probate is the court-supervised process where the executor manages your assets, pays the debts, and distributes your property to the people who inherit it. But it's supervised by the court, and so all the paperwork needs to be filed by the court, and you have to file petitions. And there are also substantial legal fees if you hire an attorney to help you with it, which in most cases will be necessary. The probate procedure also can go on for quite a few months, sometimes a year, sometimes 2 years. And so if instead you set up a trust, the process is faster and easier, and you can select the person who will manage your assets and distribute the assets. So it has a lot of disadvantages. Plus, it is private, it's not public as it is if you go through the probate process. It also allows you to distribute your assets in stages. So that's important if you have minor children and you don't want the children to get the assets, all the assets when they're 18. So you could specify in your trust that they should get a share of the assets at 18 or 25, and then maybe the rest at 28. So you can choose the ages for the distributions. So these are the basics of a trust. And I will now move on to the durable power of attorney on the next slide. A power of attorney is another important document which appoints someone called your agent to act on your behalf if you are incapacitated. The person who is authorized to act, like I said, is called the agent or sometimes attorney, in fact, and they can make important financial decisions for you. So whether you have a will and a trust or just a will, this document will help you or will help the agent to make decisions relating to paying your everyday expenses, paying taxes, paying mortgages, collecting Social Security, even investing money. They can also file and pay your income taxes. They could operate a business that you own. And they can also transfer property into a trust that you've created. They could hire someone to represent you in court if that's necessary. So there are a lot of things that this person can handle, and that's why it's very important that you choose someone that you trust. The document is typically effective when a doctor certifies that you have become incapacitated. Sometimes the documents say 2 doctors, or you could also specify a combination of people. You could, for example, say, my best friend and a doctor can determine incapacity. So there are different ways of doing that. Or you could also make it effective immediately when you sign it and give another person the right to make those decisions right away when you sign the document. That's sometimes more likely if the document is executed by an elderly person who maybe wants an adult child to help with the decisions. For younger people, I typically see that they would like doctors to certify when they become incapacitated. And then we will move on to the next slide, which is talking about the 4th document, which is an advanced healthcare directive. This is a document that is kind of like separate from the others because it's not related to your finances or your assets. It is a document that directs physicians and other medical professionals regarding the level of medical care you would like if you are unable to make decisions for yourself. So in this document, you can really let them know what your wishes are. And you can also spell out your end of life choices. So some options are, or some people will say, I want or I would like my life prolonged with whatever measures it takes. And other people will say, no, if I'm in a coma, then I would only want my life prolonged for a certain number of months. And you can also specify what kind of treatment you would like. So there are also a lot of options. And then in this document, you can also specify whether you would like to be an organ donor. And maybe some of you have already made this choice. Like if you look at your driver license, sometimes clients have like a little pink dot on there, so that means you have chosen to be an organ donor. So if you do set up an advanced healthcare directive, make sure it matches your driver license. in California, the person that you name to make decisions for you is called your agent. And many people choose a spouse, a partner, a relative, or a close friend as their agent. And I always tell my clients that I think it's really important to talk to the person you choose if you can and have a conversation about what your wishes are, because I think that will help them make decisions on your behalf. Because in many situations, it's not a black and white decision. There could be some gray zones, and it could be kind of unclear what actions should or need to be taken. And so the better they know your wishes, I think the easier it will be for them to act. So, I think in summary, some important factors in choosing an agent are: choose someone you trust and who knows you well and will honor your wishes. I think it's also important that you choose a person who can assert your wishes and be confident when dealing with doctors and medical personnel, because they might have a different opinion and could try to convince your agent that another course of action would be better. And then, it's also helpful if the person that you choose can be local or can travel. So it's okay to choose someone in a different location, but if decisions are needed, it's probably easier if they can come here and talk to the doctors. And so for international clients, I do recommend that they pick someone who could speak to a doctor in English, preferably. Of course, you can always hire a translator, but I think that makes conversations a little bit more difficult. So then we will move on to the next slide, which talks about guardianship. So when we talk about guardians, there are typically two roles that we look at. One is a guardian of the person, and that is the guardian of the person is taking care of the child on a daily basis in their home, making sure that the child's needs are met. On the other hand, the guardian of the estate is the person who manages the child's assets. And it could be the same person, but it doesn't have to be. And for those situations, or for those clients who set up a trust, most likely a guardian of the estate would not be needed, because the assets would be in the trust and the trustee would manage those assets. So when thinking about picking a guardian, again, I think it's important to have a conversation with the people that would take care of your children and help raise them, if in the unfortunate event that you and your spouse or partner have passed away. And so the way this typically works is that in your will, you write down who should be the guardian of your child or children, and it's called a nomination. But ultimately, a court would have to appoint those people and approve that they can take care of your children. So it's always a court procedure that you have to go through. And I think the reason for that is it's for the protection of the child. A judge would always want to make sure that the decision is in the best interest of the child or the children. So even if you name someone in your documents, it doesn't mean that they will be approved 100%, but a judge would, of course, try to honor your wishes. So again, like I will talk a little bit later about the implications for international clients and those choosing guardians abroad at the end when I give some advice on that. So then I think we can move on to the second part of my presentation on how the estate plan works together, or how the different documents work together. So I've covered all the basic estate planning documents, like the will, possibly a trust, a power of attorney, and an advanced healthcare directive. And so there are really two main situations when these documents are needed. The first one is if you are incapacitated. So if there's ever a situation where you cannot make decisions and you have a trust, then your trustee will take care of all the assets in your trust, such as real estate, bank accounts, stocks, and will be able to manage and make distributions for you and your family. The second document for incapacity is a durable power of attorney for finances. So the person named in that document will then manage your assets that are not in the trust, such as retirement benefits, life insurance, and also maybe assets that should be in the trust but are not, because sometimes some assets are clients forget to transfer them to the trust. It could be a bank account that was opened but not transferred. Also, if you do not have a trust, then the agent under the durable power of attorney can take care of all your financial assets and help make payments and pay taxes. The third document for incapacity is the Advanced Healthcare Directive, because it directs your agent to make medical decisions for you, just as I just described in the previous slide. And then finally, the guardians would also jump in if you're incapacitated and you have minor children. In that case, the guardian would also be appointed to take care of your children. Then the second situation where the documents are needed is in case of a death. So in that situation, if you have a trust and a pour over will, the trustee will manage the assets in the trust and the executor will take care of the pour over will. But together, these documents will work together, and it means that the trustee would take a look at what assets are there and then make a decision on how they are either distributed or managed. For example, if you have minor children, the trustee would manage the assets until they become adults. And again, I think I mentioned at the beginning, in the trust, you could specify at what ages they would receive the assets. And then at some point, the trust would end and the assets would all have been given to your beneficiaries. In your Advanced Healthcare Directive, you can also describe or express how you would like to dispose of your remains and also include organ donation. So sometimes I have clients who have very specific wishes and we write those in. It could be something like my ashes should be spread in a certain place, or I would like for them to be brought to another country. So we can include that in the will or also in the Advanced Healthcare Directive. If you have assets outside of the trust, such as retirement accounts or life insurance, then in case of a death, those will go directly to the beneficiaries, as I already mentioned. So it could be the assets could go to a spouse, or sometimes some clients name a trust, but only after careful consultation with an attorney or an accountant, because it has some tax implications. And then finally, the last piece in the situation where there is a death, then there might be a situation where you need guardians for the children. And that's again where the will hopefully have nominated some people and the judge would confirm, and then the children would be taken care of by those people. So these are the two situations. Then I would like to move on a little bit to the considerations for international estate planning. And the first item is the location of assets. In this area, in Silicon Valley, there are a lot of people from different parts of the world, and I often have clients who do have some assets in another country. So I think it's always important to take a look at those assets, what they are, and then there's a possibility that if you work with a local estate planning attorney, that we would have to consult with an attorney abroad in the country or the countries where you do have those assets to find out whether it would make sense to set up a separate estate plan in that country, or whether you can coordinate it or include it in your US plan, because every country has different laws for estate planning, and we just want to make sure that no assets get forgotten. So to give you an example, I have a fair number of clients from Germany, and they set up a plan in the US with a trust, and they own real estate in the US and in Germany. So then the question comes up, should we include the German real estate in the US plan? And so that is something that we discuss with a German lawyer, because in the end, the German lawyer will have to distribute that asset to the beneficiaries. And so we want to make sure that it would be an easy process in case of a death. And the same is true for bank accounts and other assets. We just always want to make sure that nothing gets forgotten and we have a plan on how to distribute those in case of a death. The next topic will be the selection of family and or friends abroad in US estate planning documents. So a lot of my clients ask me whether they can name friends or family members from abroad in their estate planning documents. And the answer is typically yes, except for the successor trustee position. If you do decide to set up a trust, you have to have a green card holder or a US citizen be the successor trustee. And I say green card holder or US citizen, there are some situations where it has to be a US citizen. And so I typically recommend that you choose someone who is a citizen from the beginning. I think it's much safer. And the reason for that is if you name a person who is residing outside of the US, it's possible that your trust would be considered a foreign trust and it would have some really unfavorable tax consequences. And if it's difficult for you to find a friend or family member who is a US citizen or a green card holder, there are professionals out there who can step in and take over that role. There are some private fiduciaries, or there are also some financial institutions who offer those services. I also think it's important to keep a few things in mind if you do choose someone abroad for these other roles, not the trustee, but the other documents. I think it would be great if they speak English, just so that it's easier for them to communicate with institutions here. And also, it's great if they are willing and able to travel if there's an emergency. And I also always recommend to pick someone who can handle financial and medical decisions, possibly in English, because that person will have to deal with some financial decisions, most likely. So in summary, it's, language skills are important, and I think confidence in handling financial and medical decisions. And then another point is I always recommend that you name the same person to be the trustee, the executor, the agent under your power of attorney, because it involves financial decisions, and so it's easier if that one person can manage your assets and make decisions. If you have 3 different people, they will have to coordinate and make decisions together, and it becomes much more complicated. For the Advanced Healthcare Directive, it's a little different. I think a lot of times people choose someone else, and that's okay. I think that would just work out fine with coordinating with the other, with the people who make financial decisions. So then on the next slide, I will again briefly touch on guardianship issues. As I mentioned, a lot of international clients have family abroad and would like to name a guardian abroad, and that's possible. I have a lot of clients who do this. They name parents or siblings who live in a different country. I always recommend, if you do that you also include temporary guardians in your will. And temporary guardians are, often friends or neighbors who could take care of your children until the permanent guardians arrive and are appointed by the court. Like a situation would be the parents are in an accident and the children are at school and somebody needs to pick them up and take care of them. And so it's very important to have that in place. Another important item is if you nominate guardians abroad, there could potentially be some immigration issues. If, for example, the children are citizens of the US and Argentina, and you would like for them to live with your brother who lives in France, then the children may not be allowed to live there because they're not French citizens. So, it's something to just to keep in mind if your family situation is like that and you have a lot of different citizenships and people in different places. I also always recommend that you have your passports for your children up to date. And if you have multiple citizenships, I also think it's good to get passports for all of those. It would be much easier for a guardian to travel with your child if the passport is up to date versus having to get that done once the parents are no longer able to do so. And then I also think it's very helpful to a judge if you can write a letter explaining why you think your children should live in a different country. It's another piece of evidence that they would take into consideration. And it could be, a one-page document where you say, all my family lives in France, and I really, really would like for my children to grow up close to all their family members. That would be helpful in making the decision. And then I think it's also important to revisit your estate plan to see if the guardians that you've nominated would still be a good fit for your children. Once they're old enough, you could have a conversation with them and ask them if they, would be comfortable living with the people you have chosen. And also, at a certain age, a judge would ask the children as well what their wishes are and would take that into consideration when making a decision. So then I would like to move on to the next slide, which is where I will talk about some tax considerations. I'm not a tax attorney, but I think it's always good to be very careful with tax and asset planning, especially if you live internationally and have assets in different places. So I would just like to point out a few things. Income tax, if you are a US resident, I'm sure you're aware you have to pay income taxes on your worldwide income, not just your US income. And then for the estate tax, as Emilie mentioned at the beginning, as a general rule, each US person, which is a citizen or a non-citizen with domicile in the US, can currently give away about 11 million in assets during life and at death combined tax-free. So we have a huge estate tax exemption right now. It's scheduled to sunset in 2026. Unless Congress acts at that time, it will go back to about a 5.4 million level. So we don't know what will happen at that time. If you are married and you are US citizens, you can give more than 11 million to your spouse and you can defer estate taxes that way. But if your surviving spouse is not a citizen, you are limited by the 11 million. Or if you want to give more than 11 million to your non-citizen spouse, you would have to set up a special trust, which is called a Q-dot trust. And maybe some of you have heard about this. It's a special trust. And I don't want to become too technical here. I'm certainly happy to explain it in more detail if you would like to have a phone conversation with me. But I just want to point out that there are some differences for citizens and non-citizens. Also, be mindful that estate tax is, you will pay estate tax on your worldwide assets if you are above the exemption. It's not just US assets. And sometimes with some countries, there are tax treaties. And so again, you would talk to a CPA or tax attorney to make sure that, you get all the deductions you can. And then just a general word of caution. In the last few years, there has been an increasing amount of scrutiny from the tax authorities on foreigners with assets in different countries. I'm sure you're all aware of that. So just always be careful when you transfer money. Check with your CPA or tax attorney on what needs to be reported before you make any transfers. And just on the last slide, I would like to just make another few points. I know sometimes the estate planning process can sound intimidating and it can sound complicated, but it doesn't have to be, and it can be done fairly quickly and efficiently. And we plan for the moment, so it may not be perfect, but it's better to have a plan in place that is the best you can do for right now versus not having a plan. And so with that in mind, I wish you the best of luck for your family and loved ones. And please don't forget that you can claim offers from both Emilie and myself. And I think we'll talk about that on the last slide.
Yes. So Brigitte and I have both set aside time to talk to people in more detail. If you have questions, if you'd like to learn more about doing a financial planning process or getting your estate plan done, or even reviewing your estate plan, I'm sure there are people on the call today who already have a plan.
Mm-hmm.
And actually, that was one of the questions I was thinking of, Brigitte, when you were talking. Is so what are there like triggers when people should? You mentioned you should review it, but like,
Mm-hmm.
how do you know when? How often you should review your estate plan?
Well, I think some triggers are major life changes, such as, the birth of a child or the death of a family member, maybe a job change or a change in your finances that have a big impact. And then also, just review it periodically. Ideally, it would be every 6 months. But I also know that's challenging, and I think a lot of people can find more fun things to do than look at their estate plan. But I would recommend that, or maybe if you do your financial review, just take the documents out and take a quick look and remind yourself, of the people you have chosen and whether you're still happy with those choices. So I would say 6 months to a year, ideally. And if you cannot manage, then at least if you have major changes in your life or finances.
What about when your kids become 18?
Mm-hmm. Yeah, I mean, that's another good time to review it and think about whether the ages you have chosen for distributions, are still a good match. Or sometimes I have clients who will update their beneficiary designations and actually name their children directly versus naming a trust once they're 18. So, and also when they start college, they become more independent. So that's definitely a good time to review.
And to maybe have their own documents themselves, like healthcare, power,
Yes.
financial power.
Yes, I think that would be very smart if they could set it up. I mean, it would be great if clients would have a conversation with their children when they turn 18 and ask them if they're willing to have those documents executed. I think that's great.
Um, yeah, and I had one other question I just was thinking of too. Sort of like, what do you see as the main barriers to getting the estate plan done, and how can people overcome
Yeah,
that?
how can people get started?
Yeah.
Well, I think a lot of times people are really enthusiastic and they want to get it done, but then they have to gather all the information and make the decisions. And sometimes they're like, oh, we don't want to talk about it, or we have to ask all these people. But I think sometimes once you do get started, whomever you work with, it could be me or another attorney, like would help you guide through that process and give you some timelines to work with. But I think a lot of times in their daily life, they don't want to sit down and look at all their assets and think about all these decisions. But once you start, it can be done within about 2 months, and that's not so much time. So I think just, sign up with an attorney and get started, and you will get to the end.
You'll kind of push them along to.
Yes, exactly. Yes.
Yeah. Yeah, that's good. Yeah, right. When you think of the project as like, oh my gosh, we have to do all these things versus just make a phone call. Like just
Exactly.
start.
Yes.
Yeah. And go step by step.
Mm-hmm.
That's good. That's good advice. Yeah. So just circling back to this slide, our contact information is here. We're happy to have consultation. I do a 45-minute virtual conversation. Typically, it's possible to do it in person as well if we plan ahead and share a little bit more about my financial planning process. And I think, Brigitte, you do something similar.
Yes. Yes. I typically do a phone consultation where clients can ask me any questions they want. I can talk about my law practice, my services, and also it's like 30, 45 minutes. If the clients need that time, I'm happy to answer all the questions and, try to help clients get started. So I do offer that as well.
Great. Well, thanks everyone for being on the webinar today. I hope you got something out of it, and please do be in touch if you have more questions or you would like to schedule a session.
Yes, thank you everyone.